thanked me for keeping the story in the news, and I asked how the family was doing. And at that point, Beth Silverman came storming, and I mean storming, down the hallway and physically grabbed him, pulled him away, and said, "You are not allowed to talk to him. That is
no
illegal."
murder weapon, no surveillance footage, and a private investigator who says he got physically pulled out of a courtroom hallway by the lead prosecutor herself. This is the preliminary hearing that just decided whether a platinum-selling artist stands trial for the murder of a 14-year-old girl, and the closer you look at what prosecutors actually showed a judge, the more questions start piling up. Here's what we know for certain. A Los Angeles judge has ruled there is sufficient evidence, legally probable cause, for the case against David Anthony Burke, known to fans as D4vd, to move forward to trial.
So look, there was a lot that came out of this multi-day preliminary hearing in the David case. Not only did a judge officially determine that there was sufficient evidence, sufficient probable cause to support the charges that David faces for this now to go to trial. This is all in connection with the death of 14-year-old Celeste Rivas Hernandez. But we also got a sense of what this trial could look like, the evidence, the defenses. And I got to tell you, there were aspects of the prosecution's case that were surprising. There were aspects that make me wonder whether, as of right now, they could convince a jury beyond a reasonable doubt that David committed first-degree murder. There is a caveat to that.
The charges stem from the death of 14-year-old Celeste Rivas Hernandez. Prosecutors allege Burke lured Celeste to his home in April of 2025, killed her, and then dismembered her body, with her remains later found inside a Tesla registered to him.
It's something they didn't present. But there's a lot of questions that came out of this preliminary hearing. And remember, prosecutors allege that this singer lured Celeste to his home in April of 2025, stabbed her to death, and then dismembered her body. Her remains were found in a Tesla allegedly registered to him. That he did all this, the allegation is, to hide an alleged illegal sexual relationship that he was having with her that began when she was 13. We know that David Anthony Burke, is going to be scheduled to appear in court next on August 31st. This is
the alleged motive covering up an illegal sexual relationship that prosecutors say began when Celeste was just 13. Burke is due back in court August 31st for arraignment, where the formal charges will be read into the record. And it bears repeating because it matters these are allegations. Burke has not been convicted of anything. Under the law, he is presumed innocent unless and until a jury says otherwise. But probable cause is a low bar. It is nowhere close to beyond a reasonable doubt, which is the standard a jury will actually have to apply at trial. And that gap between what a judge needs to hear and what a jury needs to hear is exactly where this case starts to get complicated. To understand what happened inside that courtroom, you need to understand who almost didn't make it inside at all. Private investigator Steve Fischer has been tracking this case since the earliest days, representing the owner of the property where Burke was staying and sitting through pretrial proceedings seated directly behind the defendant. Fischer says he was subpoenaed to testify before the grand jury, not once, but twice. And according to Fischer, when he was served, he was told he could never discuss the case publicly again, not even with his own client, because grand jury witnesses are permanently silenced.
Said this on the public record. I was a witness to the grand jury on 2 separate occasions. I have to throw this in there. Beth and I don't get along. She does not want me investigating the case. She did not like that before anything was moving in this case that we put out things like the burn cage was at the house, a chainsaw. We asked why these things weren't in evidence and why there was a 4 terabytes worth of surveillance footage from the house across the street that wasn't captured, wasn't gotten before it was overwritten. And when I was initially served, I was told that by law, and this is not the law, but I was told this, I can no longer ever speak about the case again because I'm a grand jury witness, not even to my own client. And that's simply not true. I'm an investigator. I can talk about the case, and it's the grand jurors that are bound by the secrecy of the grand jury. I can speak about my own witness testimony if I want to. I just can't speak about anything that I learned from the grand jury, which I haven't even spoken about my own testimony because I did get this handwritten
Here's
note.
the legal reality that's not accurate. Grand jury secrecy binds the jurors themselves and the proceedings, not necessarily an investigator's own separate knowledge or his own testimony. Fischer maintains he never violated any actual rule, which brings us to the moment that turned Fischer from observer into part of the story. During the hearing, Fischer says he was approached in the courtroom hallway by attorney Patrick Steinfeld, who represents Celeste's family. According to Fischer, Steinfeld simply introduced himself and thanked him for keeping the case in the public eye.
On the 2nd or 3rd day, I was in the hallway waiting to get in the courtroom, and a gentleman came up to me who I had no idea who he was, in a suit, and he said, "I'd like to introduce myself. I'm Celeste family's attorney." It was Mr. Steinfeld. And I was sitting on the bench seat, so there's a lot of reporters around. So we went to the middle of the aisle of the courtroom, and he said some very nice things. He thanked me for keeping the story in
That's
the
when
news.
Fischer says lead prosecutor Beth Silverman came down the hallway, physically pulled Steinfeld away, and told him he was not allowed to speak to Fischer, calling it illegal. The next day, on the record, Silverman told the judge Fischer had violated grand jury secrecy and said she intended to seek a warrant for his arrest, accusing him of approaching family members who were witnesses in the case.
Said that she wanted to put something on the record, and she turned around and pointed to me and said, he is not to be in this courtroom. He has broken grand jury secrecy laws. I'm having a warrant issued for his arrest. Said that he went up to the family who are witnesses, and he knows he's not allowed to talk to witnesses. He went up to the family yesterday and was trying to talk to them. And the judge, I got to say, the judge was super professional.
The judge, according to Fischer, handled it carefully, declining to wade into grand jury matters and allowing Fischer to voluntarily exit rather than making a ruling on the spot.
She said, listen, she can have you excluded because of the grand jury thing. She's like, I can't get into grand jury issues. And I said, listen, Your Honor, I'm fine leaving. I'm completely fine. I understand.
Fischer says he agreed to leave without contesting it in the moment, but Steinfeld then stood up and told the judge, for the record, that he was the one who'd approached Fischer, not the other way around.
And at that time, I got to say, it was also very professional. He stood up and said, Your Honor, I want to put on the record as well that I did approach Mr. Fischer. And at that moment, when he did that, Beth spun around and just started mouthing things to him. And she didn't even take the time to learn if it was the case that I came up to them. She just made these assumptions. Anyway, so
Fischer left the courtroom anyway. As for the warrant, Fischer says he was directly told by the bailiff walking him out that no warrant existed.
He just, they standard procedure. They just walk side by side with you as you're leaving the courtroom. And I said, there's not a warrant for my arrest. He's like, no, there's not a warrant for your arrest. Okay. So I think it's just...
He also says he was never actually called to testify at this preliminary hearing at all, despite being subpoenaed to the grand jury on 2 separate occasions.
Question about that. So you were never asked at one point to testify during this preliminary hearing?
Never.
And
I've never been talked. I've never been subpoenaed. I've never been talked by email, phone, or anything about this prelim at all.
Now here's the legal explainer worth sitting with for a second. None of this back and forth is evidence against David Burke. It's a subplot about how contentious this case has become behind the scenes, and about a prosecutor who, according to her own private investigator adversary, appears determined to control who talks and what gets said. Whether that's aggressive case management or something else is a fair question to ask. It is not, on its own, proof of anything about guilt or innocence. So let's get to the evidence that actually matters, what prosecutors put in front of the judge charge by charge. On the sexual abuse charges, the case looks, by most accounts, extremely difficult for the defense to overcome.
Yeah, I mean, I don't see any way of overcoming that. Listen, you have the West Hollywood Sheriff's deputy who told him she was a 13-year-old runaway. Listen, he knew where she went to school. These phones that were passed to her, these are through classmates at that school. So I think
prosecutors presented alleged sexually explicit images reportedly found on Burke's phone, texts referencing a pregnancy and abortion, and testimony that a West Hollywood sheriff's deputy had previously told Burke that Celeste was a 13-year-old runaway. Fischer noted that even the defense, in closing arguments, reportedly leaned into the framing that Burke loved her, which, if true, is close to conceding the underlying relationship rather than denying it.
So I think that's something, and I think they even kind of admitted that, because in the closing, from what I understand, I wasn't in there yesterday, but they said David was in love with her. And so right there, I mean, they're essentially admitting it.
On mutilation of human remains, the prosecution pointed to circumstantial evidence, 11 air fresheners in the Tesla, cadaver bags, a blue inflatable pool with cuts in it found in Burke's garage, matching blue plastic fragments allegedly found with Celeste's remains, and a missing finger, the one that reportedly bore a tattoo of Burke's name.
So the unlawful mutilation of human remains, to me, I also feel that feels pretty strong, although there's aspects of it. So the evidence presented by the prosecution alleged that this Tesla, there was a strong odor, that there was 11 air fresheners. Why would you have 11 air fresheners? That her passport was apparently found on a road in Santa Barbara, that they tracked him allegedly there multiple times going to that area through phone and Tesla data. The first time on the night of April 23rd, right after prosecutors say that he killed her, that was the allegation, that he allegedly bought chainsaws, a mop system, cadaver bags, a blue inflatable pool that was delivered to his home under an alias. The pool allegedly found in his garage had cuts. They said there's blue plastic fragments that were reportedly found embedded in Celeste's remains. The matching tattoos on her finger that David's name was tattooed on her left ring finger. That finger was missing, so the idea would be he was doing this so she
Prosecutors also cited phone and vehicle data allegedly placing Burke on multiple trips to a remote stretch of road in Santa Barbara, where Celeste's passport was later found. But Fischer raised a real hole here. The 2 chainsaws recovered from Burke's home tested negative for blood. There is, as of this hearing, no confirmed murder weapon.
He didn't plan to kill her. Do you know who actually drove or used his devices? The 2 chainsaws found in his home tested negative for blood. No murder weapon. We don't have the actual murder weapon. There's a conversation if there's a missing chainsaw. Fake blood in the home? So I don't know the idea. All these items were purchased for what, a music shoot? But I thought
which leads to the murder charge itself. The most serious count, carrying special circumstance allegations of lying in wait, killing a witness, and killing for financial gain. This is where Fischer, despite saying plainly that he personally believes Burke is responsible, thinks the prosecution's foundation was the thinnest.
I think David did this. 100%. I believe that. I really do. I've been very vocal about that. However, there is a difference between him doing this and possibly being overcharged, to a point where can they prove that? I think that, let's talk about the special circumstances first. I think the luring, I don't see it myself. I think that she was willing to come to the house. I didn't see any desperate attempt by him to get her there at that moment, or I don't think he conned her, or, by saying, making her certain promises. I think that's going to be a tough one there. And even the premeditation, the mens rea of this whole thing is, I question, because David comes out, he's playing virtual reality video games while she's on her way there. He's like, hey, I left the door open. He doesn't seem like a guy who's waiting, rehearsing, getting maths down or anything like that. And also we hear his parents were possibly in town. And in the past, they've stayed at that house. It makes you wonder who exactly was there at the time. But it could be tough on the premeditation side. I do think it opens a door for the defense to say, listen, he did love her. It was inappropriate, but he loved her, and they got there, and there was a heat of the moment battle. And to try and knock this down to second degree or something like that. I don't know if he intended from the time he sent her that Uber for this to happen. I 100% believe in my heart and know in my heart he did this, but I do hope that they have more to actually back up those first degree premeditated, death penalty case claims. Possible death penalty.
He questioned the lying in wait allegation, noting there's no clear evidence Burke lured Celeste with any elaborate deception. She appears to have come to the house willingly. He also questioned premeditation, pointing out testimony that Burke was reportedly playing video games and had simply left the door unlocked around the time Celeste arrived. Not exactly the picture of someone staging an ambush. There's no surveillance footage capturing her entering the home, and even the Uber driver reportedly couldn't confirm the exact drop-off location.
Particularly since they also said the Uber driver can't tell exactly where he dropped Celeste off. There's no surveillance footage of her coming into the house. So even
LA County District Attorney Nathan Hochman seemed to acknowledge in public remarks that this preliminary hearing represented only a fraction of the prosecution's total evidence. With more expected at trial, once witnesses can be properly examined and hearsay restrictions tighten under trial
rules. Not everything
rules.
They have.
So the other idea that you need to have is that a preliminary hearing is not designed for the prosecution to present all its evidence. Mr. Quealy is correct from the Los Angeles Times that there was additional evidence that was actually considered in this case that we anticipate being presented at trial. I'm not going to go into the specifics of that additional evidence, only to say that we presented a significant but small fraction of our evidence in this preliminary hearing. At a trial, we will present all our evidence because the proof at a trial will be beyond a reasonable doubt. We will not be allowed to use certain hearsay that you can use in a preliminary hearing that you cannot use in a trial. It has to be admissible evidence, and the witnesses will need to come in to establish all the foundation, the relevancy, and overcome any objections to the type of evidence. So you are correct that there will be additional and significant evidence presented at a trial that wasn't presented here.
Fischer flagged something specific in that same statement, Hochman's reference to unnamed recipient witnesses, people with apparent direct knowledge of what happened, who did not testify at this hearing at all.
Well, he used the word recipient witnesses, and these are people that have direct knowledge of something that happened. And I think that's important here because, keep in mind, going back even to the brief that was filed, which isn't really even standard practice to have these briefs filed like they did. But they said that he, paraphrasing here, but he watched her bleed out or stood by as if she bled out or something to that effect. which makes it seem like, is there a witness, or did he confess to somebody that, like, hey, I did this and I sat there, I watched her die or something? But then he uses the word precipient witnesses, which I don't think he meant to use, because he did seem to try and, like, almost cover that
So
up.
where does that leave things heading into the August 31st arraignment? The sexual abuse charges appear to be the prosecution's strongest ground. The mutilation charge looks solid but not airtight, and the first-degree murder charge, with its most severe special circumstances, is the one legal observers, including an investigator who says outright he believes Burke is guilty, see as the most vulnerable to being challenged or potentially reduced before this ever reaches a jury. None of that changes the presumption of innocence Burke is legally owed.
He has not been found guilty of anything. He is innocent unless proven guilty. This is just the next stage. This now moves
But it does mean
forward.
the real fight in this case may not be about whether something happened to Celeste Rivas Hernandez. It may be about exactly what prosecutors can actually prove happened and what degree of responsibility a jury is willing to assign. That gap is where this case will live until trial. Subscribe for continuing coverage as the arraignment and pretrial hearings unfold.